Then you come to the 21st Amendment Act of 1967, which is important. Why? Because it made changes to the 8th schedule. Okay. So 8th schedule was, so 7th schedule is basically where the three lists, the state list, the union list and the conference list have been mentioned, or the division of the legislative powers between state and union have been mentioned. Then 8th schedule, if we talk about, it mentions about the scheduled languages. So India as a nation does not have a national language. I repeat, we do not have a national language. Second, we have two official languages. We had Hindi, but then we also had provision for English to be extendable to a certain period of time. Okay. And how many scheduled languages we have? We have 22 scheduled languages. Okay. So earlier, so basically, so they got added, like there were additions, 1 plus 3 plus 4 like this. So if you take, we had originally, I think, 14 languages, but over time, due to constitutional amendments, some languages got added, and now we have 22 scheduled languages. English is not a scheduled languages. English is not a scheduled language. I repeat my word. English is not a scheduled language. Okay, Hindi is a scheduled language. Okay, before you forget. So now you will see that Sindhi. So we already had 14 languages. Now there will be an introduction. So via 21st Amendment Act, what are we introducing? We are introducing Sindhi also in the scheduled languages list. Okay. Then after that you will find via 71st Amendment also there will be addition of certain languages, and then through 92. So how did I learn it? 21, 71, and then you add it, it becomes 92. So that is how you can make short tricks to actually remember the amendments also. Okay. Then we come to the 22nd Amendment Act of 1969. It facilitated the creation of a new autonomous state of Meghalaya within the state of Assam. So earlier, see, Assam actually was a state. If today we see what we see as Assam, okay, like this probably, this Assam is actually 1/3 of what it used to be earlier. Why? Because out of this Assam only, you will find many of the northeastern states have been separated and given a separate statehood, made a separate state. Okay. So here also you can see now out of a state of Assam, you will find that Meghalaya as a sub-state has emerged. Okay. Sub-state means there will be certain you can say certain subjects wherein the Meghalaya will be coordinating with Assam, and that is why it is called as a sub-state. That means it is still not a complete independent state. It was earlier the case, but now what is happening with the 22nd Amendment Act? Basically, Meghalaya has been created as a new autonomous state, like fully independent state. It is empowered to take its own decisions. Okay. Then we come to the 23rd Amendment Act of 1969. It extended the reservation of seats for SCs and STs. Okay. And special representation for Anglo-Indians in Lok Sabha and state legislative assemblies. So earlier we extended it till 1970. Now we have extended it for 10 more years till 1980. And then you will see it has been kept on going, increasing. And I think the last date is 2026. So till then they have to provide them reservation. Okay. Then you come to a very important amendment, these two. Okay. Why? Because they are related with the judiciary. Judiciary passed something, then this act was passed, and then then again it went to judiciary quashed, and then again some amendment act was passed. So this was a cycle which was going on. Okay. So now we will start with the 24th Amendment Act, which was passed in 1971. And as I have just mentioned that, there was a tussle between the court and the parliament, and you will find that these both are just basically trying to, if parliament is passing an act, judiciary is trying to make it void because it is void according to the constitution what is there, and then parliament in subsequent of it will amend the constitution. So what happens here is that the parliament basically passes this act to ensure that it can amend any part of the constitution, including fundamental rights. And why has parliament done that? Because Supreme Court in an earlier case, which was called as the Golaknath case, Supreme Court in the earlier case called as Golaknath case, it mentioned clearly that fundamental rights are sacrosanct. They cannot be touched. Okay. And to just reverse the order, what has parliament done? Parliament has now passed an amendment. So they have constitution, they have amended the constitution itself to ensure that they can amend any part of the constitution, including fundamental rights, and they are not sacrosanct. Okay. And second, it made it compulsorily for the president to give his assent to the constitution amendment bill. This was what I was talking about. As I told you the procedure of the constitution amendment, and I told you that there is no provision of joint meeting. There is no prior recommendation of president needed to introduce the bill in the parliament, and also president cannot either return the bill or cannot basically ask for cannot return or reject the bill, the constitutional amendment bill. It has to actually give his assent to the constitutional amendment. And this particular, why that president has to compulsorily sign, it was brought about by the 24th Amendment Act of 1971. Okay. After this, what will happen? After this, basically, there was another Amendment Act which was passed in the passed as 25th Amendment Act of 1971. Okay, and what did it do? It curtailed the fundamental right to property. Okay, and then it provided that any law which made to give effect of the directive principles of Article 39 B and C, it cannot be challenged in the court on the ground of violation, that it is not guaranteeing us the rights given in the Article 14, 19 and 31. What does this long sentence say? It tells you that via 25th Amendment, government is saying that if it is bringing about, the parliament is saying if it is bringing about any law which is basically to give or to fulfill its obligations under DPSP Article 39, what? B, yeah, C, then these particular laws which the government has implemented to give effect to these particular DPSPs, they cannot be challenged on the ground that they are violating Article 14, which is right to equality, Article 19, freedom of speech and expression, and Article 31, which is the right to property, which was then repealed later. Okay, so these were major amendments, and these you have to remember because these are two very important constitutional amendment acts. Okay,